I'll make the first half, really good. All right, welcome everyone. Thank you for coming to our final discussion on student rights in 2017. It's nice to have a lot of folks back from our last 3 discussions and some new faces as well. I think this is a great way to wrap up the series with student discipline. We've talked about student speech, student privacy rights, protections from discrimination, and a lot of that leads up to this question of student discipline, how students are disciplined in school, what schools can do. So the first thing I want to talk about is a little brainstorming exercise. Uh-oh. There we go. There we go. I want to brainstorm who are the stakeholders with student discipline. What is at stake with student discipline? So when we're talking about students leaving class, potentially being suspended or expelled from school, who are the stakeholders in that? And I'm going to put a few of these on the board just so we have them in mind. I don't know if we want to move the camera while I so the student discipline, right? Yeah. Okay, who else?
Teachers. Family.
I heard teachers. I heard family, students' family.
And including the students' siblings.
Mm-hmm.
And his classmates also, obviously.
Teachers, parents, siblings. Administrators.
The school district.
District police, that was another one I had thought of kind of last minute. That's a good one.
Community at large.
Great. And someone said other students, right?
Yes, classmates.
So maybe, can we break that down anymore? Are there different sort of groups of classmates that could be affected by this?
Well, the classmates immediately in the student's
Mm-hmm.
immediate environment.
Mm-hmm.
And then obviously.
So the ones that are actually impacted by the action.
Right.
And then the community as a whole can be, if there's a disruption or, right?
Right.
So, well, I'll put classmates for now. Who else?
School board.
School board. I'll put that's separate than from administrators. I'll say that's, yeah, you're right. School board. Who else? Anyone else? Let's see what I got here. Yes?
You wouldn't think of this one, but hearing officer.
Hearing officer. The hearing officer, and we'll talk about it. I'll leave that with school board since it's going to be their agent who does that.
What about if you have a peer review, a student peer review panel? Is that somewhere between the
Yeah,
district?
let's put that down. Peer reviewers. Sorry about my handwriting. All right. So we said communities. Any others you can think of?
Here's one that's come to be from out in left field. Put down community clergy.
Community clergy, that's interesting. And yeah.
Counselors.
Oh, can't spell. There we go. Clergy. You said counselors? Counselors, I like that. All right, I'm running out of space here, so let me see if I got any more. How about taxpayers? So community, but maybe more like taxpayers at large or society at large, right?
Taxpayers would be best, I think.
Taxpayers. I'm going to put down, in addition to community, I'm going to put society. I think those are 2 separate things. What about, yes?
What's happening a lot now is sending them to an alternative school.
Mm-hmm. So I think this might tie in with the next one I was going to say. I was going to say public services. I think that might fall. I guess those are separate, alternative schools and public services, right? Because public services are potentially impacted. So let's put alternative schools, not to be confused with alternative facts, and public services. Anything else? Military recruiters. You know, you're right, but I'm going to leave that one off for now. You know, actually, I am going to put that on. You know what? I am, because it is an impacted discipline, isn't it now? Right, right.
Well, if you're gonna put military recruiters, you have to say private schools.
Private schools, I'll put that as well. So I'm going to cut this off here so we can keep going, but I want to leave these up because, you know, I think these are really important to think about as we put student discipline into context, especially with the new law in Illinois and as we talk about improvements. So I just want to point out how broad some of these are. We're talking about taxpayers, community, society, military recruiters, and a lot of this has to do with the impact of discipline. It has far-ranging effects, especially when you're talking about pushing kids out of school. So, brief overview of what we will cover. We're going to talk about statistics, quantifying discipline and inequalities. We can talk about trends a little bit. Due process and previous law. So what are your constitutional protections, and what did the law look like in Illinois before brand new Senate Bill 100, which went into effect for this current school year. We will cover Senate Bill 100. We're going to do a overview of it, and we're going to talk about sort of the pros and cons, what everyone thinks of it. And then with the time remaining, we're going to talk about some special issues on college campuses. So the first part of this is going to focus largely on high schools, as we have been, but there are some special issues on college campuses, which I know are it's a trending topic right now, very important issues. So we are going to start with some statistics, and if we can keep passing around that study we have on the preschool study, it ties in with this. So black students account for 35% of all students suspended at least once, and they account for 39% of expulsions. That's despite only being 18% of the public school population. Any thoughts on that so far? Even obvious thoughts on that?
Well, how are they broken down? Are you looking at African American students who maybe have a previous discipline issue? Are these first-time offenders? Have they broken it down
So,
by African Americans or black students who are fairly new to the United States? Are they Caribbean or?
So we're getting a little granular with the study I have, but this is from a North Carolina study. And this is for first-time offenders suspended at higher rates. So first-time offenders. For black students, I'll just hand this to you because I don't have a good copy for the room. For cell phone offenses, for displays of affection, dress code violations, and disruptive behavior, essentially for all of those, black students are suspended almost twice as often for first offenses. So we're not even talking about repeat offenders, at least who have been suspended before. We're talking about for the first offense. Ted, did you? Oh, yeah, Boris.
Do those figures take into account whether it's a white teacher, a black teacher, white principal, black teacher?
This one doesn't, but there's been a lot of study of that. And we'll actually, we're going to move on a little bit to implicit bias in a second, and we'll talk about that, because that is an important point, where you have differences between the race and background of the teacher. Yes, Leon?
You're getting these statistics from the Department of Education, right?
A lot of these are from the Department of Education. I looked at the ACLU as well. I can tell you that my
Figure for the 3.6 times.
yeah, that's directly from the Department of Education.
Yeah. The other one is students with disabilities are also have some factor
Yes.
more likely.
Yes, they do. So, you know, we're talking about first-time offenders here, and there are things like economic inequalities that affect this. You know, districts with fewer resources might be quicker to resort to harsher punishments. They might feel a need to get more control of the classroom quickly. They might not have areas or resources to monitor students who have just been pulled out of class temporarily. That is a major issue. But look at all these stakeholders we talked about. We're talking about things way down the line, about what happens once you're pulled out of school, once you're suspended for a long time or expelled. You might end up at a private school or an alternative school. You might end up joining the military. When we're talking about taxpayers and society and police, we're talking about the impact of, well, maybe ending up as a criminal. And that's far more likely to happen once you've been suspended.
Yeah, I actually experienced that. I was on the school board in 1968.
Mm-hmm.
1968, it was right after Martin Luther King was killed, and all hell broke loose. And it wasn't just in Argo High School, but
all over.
Mm-hmm. And we had to hire an attorney to make, this was after Tinker came down, and we had
Mm-hmm.
to hire an attorney to make sure the rights were followed.
Right.
We got sued by a teacher that was involved in that with real money.
Mm-hmm.
So I actually experienced that. Now,
Yeah.
Now, of course, it isn't that kind of event does occur these days.
Mm-hmm.
The protests, whatever,
Mm-hmm.
more happening now on college campuses, but it was happening then in high school.
Yeah, absolutely. So that next stat, which Leon actually mentioned, that black preschoolers are 3.6 times as likely to be suspended as their white classmates. So it might, there might be some resources playing into that, like I said, but it's clearly there is some inherent bias. And the study I'm passing around, that and others have found that the inherent bias isn't just limited to white teachers either. Unfortunately, sometimes black teachers have inherent bias against black students. And that's a reality. So when we're talking about a lot of the laws that exist and due process and the new law in Illinois, a lot of it is meant to address inequalities, but those laws aren't going to affect inherent bias. That's something at a very deep level where there's only so much impact that the law can have on that. It's more of a shift in terms of culture, education, training. And a lot of the law that we're talking about, it can go a long way in helping fix these issues and making sure that students are treated fairly. But there has to be somewhat of a change in attitudes if we're going to get students of color to have more equality. And this last stat, well, it's not a stat, but it's just a comment, and there are statistics on it, but suspended or expelled students are far more likely to end up contacting the law in the criminal justice system. They're about twice as likely to end up in the juvenile system if they're underage after being suspended or expelled within the next year. So, due process for students. We've talked about in previous discussions the 14th Amendment. No state shall deprive any person of life, liberty, or property without due process of law. Well, does that apply to students? Yes?
I think because they're minors, it might not.
I think that's an interesting point, that they're minors. We talked about that a little bit previously, right? What is there any case that, for the folks who were here at previous discussions, that you could think of that might apply?
There is one during, I think that there was a civil rights protest that some black students were involved in, and they were suspended without a hearing, and the Supreme Court basically ruled that yes, their due process right was violated, and that
It's very similar facts. I was going to just go with Tinker, which Ted, I think, mentioned earlier, which says your rights don't end at the schoolhouse gate, right? Your constitutional rights. And we had some pushback on that, right? We've seen in practice that isn't always the case. And, as Mike mentioned, they're underage students. There is some level of what's called in loco parentis, where the school is acting as a parent and able to discipline. Leon, did you have something? Oh, okay. So one of the early cases, before we even get to Goss v. Lopez, this is a companion case to Brown v. Board of Education, which, as you may recall, desegregated the schools. That said that you can't have separate but equal. It's inherently unequal. Bowling v. Sharp, a companion case to Brown v. Board of Education, in that the Supreme Court held that the word liberty encompassed a child's right to public education. So when we get to Goss v. Lopez, that's under consideration as we're talking about as schools suspending students. Ohio had a law that allowed students to be suspended for up to 10 days or expelled under certain circumstances. For the suspensions, no hearing was required. The expulsions, they had to have a hearing, and in both instances, there's written notification to the parents, so the parents understand what's going on. The student was suspended for 10 days in that case. How do you think the Supreme Court ruled? No hearing, since it was under that Ohio law. Any guesses?
I think the Supreme Court ruled against the school district because there was a lack of due process.
That is correct. It was Justice White writing for the majority. It was a 5-4 decision. So this was very close. The minority, some of them thought that students, well, really didn't have very much in terms of rights in schools. There's still an argument today. We talked about in our student speech discussion, Justice Thomas doesn't think students in school should have their constitutional rights. It's a school acting as parents. That argument's still going today. The court reiterated the Tinker Standard, which had been decided 6 years prior. And the interesting thing here is they didn't really hand down too much of a procedure. They said that they were focusing on this suspension of 10 days or less. And they said that the procedure is kind of informal. You need to have some kind of hearing. You need to be able to present the case, present evidence. But they didn't go much beyond that. They said that if there's an expulsion or something more, that you might need more in terms of procedure. Well, where's that leave you, right? You know, what would you do if you're a school administrator? And I'm going to exclude Ted from this since he was a school board member. What would you do if you're a school board in terms of having a hearing and due process under that guidance from the Supreme Court, saying you have to have some hearing, you know, allow them to present the case and present some evidence and an argument, but it's pretty informal.
Well, I'm on a school board right now too, an elementary school board, so we don't get discipline ones. But we had one case and it required numerous bringing in psychologists for this problem, meetings with the parents, meeting with the administrators. So we had to have a lot of hearings
Yeah.
before we could take any action.
You know, a lot depends on the circumstances. Facts are important. You know, if you got all hell breaking loose in the community because of one incident and the press is out there, you never know what's going to happen. So the school board's got to take extra caution. You know, attorneys on either side are certainly representing the parents, or whether they come up with some very innovative ways to sue.
Oh yeah, that's very true.
In the Goss, okay. In the Goss v. Lopez, that was in Ohio?
In Ohio, yes.
What city?
Ooh, that's a good question.
Because it was 1975 when the ruling was passed down?
That is when the Supreme Court ruling came down. So I am assuming, you know, we talked about this previously. These high school cases, those guys were probably out of school by the time this case came down.
Okay.
So
I guess my question is the Supreme Court rules because there's no due process, and you know, for lack of a better word, an environmental situation. Say this was 2 years before. You're looking at 1973. It's a pretty volatile time in American history.
absolutely.
If this is Centerville, Ohio, okay, upper class town, okay, what's going on there? Maybe they're going to look at it a little bit more. If it's Cleveland or Cincinnati, and maybe there's a little bit more unrest in those towns, and maybe the tensions are heightened. Doesn't make suspension right, but you know, the environmental impact, if you will, could have really impacted a knee-jerk reaction.
And I think that leads to some of the struggles that district courts have had since then. The Supreme Court didn't offer much guidance. The Supreme Court has not spoken very much on student due process since then. How about if, I mean, Ted was talking about 1968, where you're talking, what, dozens, hundreds of students facing discipline?
All over.
Yeah. How do you deal with that if you're a school administrator? Are you allowed to suspend the students before you have a formal hearing? Are you allowed to expel them? If you're leading to expulsion, what should you do? Can you remove those students?
If it's written in your code that if the offense is severe enough, that you have a reason to take prejudicial action,
So maybe like a zero tolerance policy?
Well, again, I'm coming
Yeah.
from the background
Mhm.
of higher education, but yeah, if there's like a sexual assault or something like that, they'll suspend a student. The student can appeal this pre-hearing suspension, but for the most part, there's a sufficient reason to actually take some
Yeah.
preliminary sanction.
Yeah. Yeah.
The circumstances are very important. We had things under control at Arco High School, but the proviso Eastley did not.
Mm-hmm.
The star basketball player, Cole Hock, the basketball coach, and there were all kinds of things. They ended up with about 25 expulsions. So
Holy cow.
things were running pretty high. So when you've got that kind of atmosphere, what do? You've got to consider what's happening. And we had television cameras come out there, and the school was closed down in 3 days.
Yeah.
So,
Yeah.
One single incident isn't that important as when all hell is breaking loose.
Nothing? Okay. One thing that I think the courts have pushed towards, the lower courts that is, and that I see as best practices a lot, is to have some form of informal proceedings right away. If you're going to suspend a student, make sure that the principal is, because it's going to be the principal making these decisions right away, or a dean, someone along those lines. It's not going to be the school board. Get something in writing, put those reasons down, and try to have a preliminary investigation right away.
There is one other thing. I mentioned hearing officer. Let me tell you, the hearing officer becomes very important.
Very.
Fair hand. So there are a lot of other people involved when something like this happens, when you have that kind of situation. Now of course, if you've got a situation where there's zero tolerance, that even gets worse. Any offense.
Absolutely. And zero tolerance policies, what those are is where you have a certain type of offense and there's automatic suspension or expulsion. The administrators essentially don't have the discretion to say, well, we're not going to suspend you for that. And those are, they're very controversial. They've come up a lot, probably in the last 25 years, and then maybe over the last 10, there's finally been some pushback and some people saying maybe those are too harsh. Maybe they result in some unfair outcomes.
I'm just curious, for the school board and former school board members, is there a requirement in the Illinois school code that stipulates how suspensions should be handled?
Yes.
Yes, that's
So there should be some people.
Well, I don't mean to step on their feet, but we'll get into that. There's stipulations under the old code and under the new Senate Bill 100 that sort of supplement those and really focus on it a lot more. I'm pretty excited about the new law, even if I don't think it's perfect. Do you guys? You guys probably could talk more about how you implement it. In terms of the statute's fairly it's a fairly brief outline and leaves a lot to the schools to implement. So maybe when we get to those slides, if you guys are willing to talk more about how your district's implemented, I think that would be great. But I don't want to push you towards that, but if you can think about it. So briefly, I want to cover this other case here, Ingraham v. Wright, 1977. So again, it's the mid-70s. This is a 14-year-old 8th grader. The facts of the case, he refused to get off his stage in the school. The teacher told him to, he refused. They brought him into the office, and the principal asked him about it, and he lied about it. He said, no, I didn't do that, or something along those lines. And the principal said, well, go over the desk, you're getting paddled, and pulled the paddle down. The student refused to comply. A couple other people were brought in. They held him down, and the principal paddled him. He paddled him to the point where it left welts. It said he had a hematoma and had to get medical attention. They sued. The parents sued. This was in Florida, and they argued that this violated his 8th and 14th Amendment rights. What do you think? Miriam's nodding her head yes.
I think the principal should have been charged with assault.
That's where I was going.
Okay.
Eighth Amendment.
8th Amendment, I should specify, I'm sorry. That is cruel and unusual punishment. What do you guys think? Does it violate the Eighth Amendment? Does anyone think it doesn't violate the Eighth Amendment? Cruel and unusual punishment.
I think it does.
You think it does? How about 14th Amendment, due process? So no hearing and they did this. The Supreme Court ruled this did not violate his 8th or 14th Amendment rights.
On what grounds?
On what grounds? They said, well, it's not cruel and unusual punishment. I mean, you know, I think what they probably were worried about was they don't think that corporal punishment in general violates the Eighth Amendment, and they were probably worried about having that ruling. This also was 40 years ago, remember. Whether they would rule that severe of a beating was, I don't think they would get a case today where it was that severe of a beating. But I think they were worried about saying that corporal punishment in general was cruel and unusual punishment. For the 14th Amendment, they essentially just said this was not depriving him of his rights. This was not something that rose to the level of, the way they frame going to school, so like a suspension, is as a property right. They say that because the states provide free education, when they suspend you, they're actually affecting your property rights.
I question your choice of words. When you said the Supreme Court worries about something, it's not up to them to worry about something.
That's true. That's true. But there are always, you know, human considerations. It's not it's people up there.
One of the problems you have with the Eighth Amendment, there are justices who want to go back to the original meaning and what actually existed.
Yeah.
when the Constitution was passed.
Yeah.
And let me tell you, there were all kinds of punishments.
Oh, yeah.
where you'd say
Yeah.
that
And, you know, along with that, I think we are talking 40 years ago, and when they talk about the Eighth Amendment, they're often talking about the expectations of society and what is acceptable. And I think in the mid-'70s, I think there was a lot more acceptance for corporal punishment than there is today.
Anecdotally, I went to school in Oak Park, and I can remember in first and second grade being terrified of the principal's paddling machine,
Yeah.
which I did not,
Were
no
you-
one ever saw it
and
or anything, but you
was
better
that public-
behave yourself.
Was that public school?
It was a public school.
But they're civilized, you know.
How about
Yeah, well, you know.
how about today? Do you think that so obviously the other thing, and the Florida Supreme Court had said, and then the U.S. Supreme Court, I believe, agreed. They said that you know, as Porras said, no, not Porras. I'm sorry, Don said. You said that he should be charged with assault. They said that state tort law could handle this. So presumably criminal law could too if he broke a criminal code, and you know, state tort law in terms of monetary damages for any assault if he violated the student that way. I think that's a good point, and states have obviously implemented rules barring some punishments, even if the Constitution doesn't bar it. Yes.
well, you know, every state has their own constitution.
Mhm.
So they can have
Sure.
their own civil rights, and if it's more broadly, state courts more broadly interpreted than the Supreme Court, they're going to bring a lawsuit under
Yeah,
state
yeah.
law.
So, any thoughts? What do you think? Do you think generally, do you think corporal punishment today is allowed in private schools? In private schools.
I don't know about today. I've heard of events in Catholic high schools where a guy would get a slap in the face.
Yeah, it's going to go to state law, and there are states that allow it in private schools. So, how about in public schools? Is it allowed in public schools in any states?
No.
I wouldn't think so.
So I'm going to read you a list of states.
It's a lawsuit.
Alabama, Arizona, Arkansas, Colorado, Florida, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, North Carolina, Oklahoma, South Carolina, Tennessee, Texas, and Wyoming. All allowed. As of 2015, all allow corporal punishment in public schools.
And how do they define corporal punishment?
I don't know how they all define it, but you know, some form of spanking or something along those lines. It is still allowed in 2017. Now, that's going to go to community standards, and you're going to have school board policies that probably ban that in a lot of places, but it is not illegal in all those states. We're not going to talk about that too much more because we can get into the law in Illinois, which was not in there, but I thought that was important because it was something that came up as I was doing research. And when I started to do my research, I was scratching my head because I could have sworn I remembered something about it. And I knew I had looked up private schools and found that it was legal there, but sure enough.
But do you have knowledge, you have any thoughts on the reason why all those states have approved it?
Well, I think it isn't that they've approved it. I think it's that they haven't banned it. I think that I think that's that the other states are proactive, and you look a lot of these states that are involved. I mean, I hate to say it, but a lot of them coincide with the states that don't have anti-bullying laws or LGBT protections. So some of these more proactive laws that protect students, they don't have them. They have maybe more of a libertarian mindset, if you can call it that. I'm not sure, because you're just talking about protecting individuals when you're protecting students. So, all right.
And libertarians care about individual rights.
Yeah. So I don't know. It's tough. All right. Let's move on to Illinois. So we're going to talk about the law before Senate Bill 100. So most of these policies that we're going to be talking about are still in effect. Senate Bill 100 is meant to enhance protections for students, give them more due process, make sure that schools are giving more thoughtful punishments and not just giving these blanket punishments that disproportionately affect minority students and just sort of set less students with less opportunity into that school-to-prison pipeline. So one of the first things that we have is this Parent-Teacher Advisory Committee. The state mandates that each school district has a committee, including parents and teachers, and they're supposed to work with the school board to set up some of the disciplinary rules. This did not cover charter schools before Senate Bill 100, so to preview, it now covers charter schools explicitly. It also specified that they should talk about school discipline, including bus policy and including searches. It didn't include bullying. Bullying, anti-bullying laws are pretty new in Illinois. They've come in the last 5 or 10 years. Those often involve a lot of off-campus incidents, spilling onto campus. Parents are highly involved in a lot of the situations you see. I'm sure you guys have read news articles and see where it's, this back and forth of on-campus, off-campus. So I think it's really important to note that we didn't have that before, and we'll talk a little bit more about why it's in there now. They also talk about setting up a reporting system between the school and law enforcement. A lot of these schools have a student resource officer who's working in the schools. Might be a little easier to share information there, but even when they don't, they're supposed to be setting up a system that when you have a student commit a criminal offense, the school finds out about it, and if it happens in the school, that they notify police. They also had expulsion requirements before. You have to send a request for the parents to show up at a hearing, and that hearing, it can be at the board meeting or it can be a hearing officer, which Ted mentioned. That is going to be set by district policy, whether it's the school board, the whole school board, or a hearing officer. If it's the school board, even though it'll happen probably at a public meeting, they are allowed to go into executive session. They will go into executive session to protect that student's privacy rights. So the student will be behind closed doors when he or she argues the case. The board or hearing officer will state a reason for dismissal and the date of the expulsion. So that's pretty important that they have to have that reason in there. Now, previously, they didn't have to do very much there. Just a basic reason would fulfill this requirement under Illinois law, at least. We can get into the constitutional issues, and I think there were some arguments there previously, but the statute did not set too much up. They also have to have transfer to an alternative program. So, Ted, you mentioned the alternative schools. Can you tell us a little more about alternative schools?
Well, they've been, it was interesting. I had a relative who was in Michigan, and he didn't get a hearing. There was violations of a number of federal rules. They sent him an alternative school. It was actually like a prison. And
Wow.
that with a lot of protests from parents that ultimately changed. But some school districts are behind the times.
Mm-hmm.
So alternative schools can be just an alternative prison.
Yeah, yeah.
And
So it doesn't necessarily take you off that school to prison pipeline. It's essentially it's almost an intermediate step.
And they're not regulated very well, and
Mhm.
lawsuits are filed, and we have 50 states. There's a
Yeah.
lot of stuff happening.
Yeah.
I'm sorry.
Yeah, go ahead.
Is there a guide or are there parameters for as to the reach of why a school can discipline a student?
Mm-hmm.
Okay, if there's a fight in the
Yeah.
building or graffiti or vandalism,
Yeah.
some kind of criminal act in the building, that's fine. Can a school or district
Mm-hmm.
discipline a student for something they might post in a blog? You know,
Yeah,
I
yeah.
think that
Yeah, and we'll
this
get
is
into that a little more, but yeah, absolutely. Especially what they're going to be looking for is a nexus between what happened on that blog and what's happening in the school. The law explicitly, and we'll get into this, the law explicitly says if you make a threat on the internet and it can be accessed in school and it's a credible threat to, or viewed as a credible threat to a student, employee, other personnel, you can be expelled.
What if it's
or
just a
suspended.
comment about a teacher?
I think it would probably depend. You know, they're going to look at that nexus to the school if it's something like where they're making a threat or if it's just a complaint. You have, you know, even in school, we've talked about you have your First Amendment rights. Out of school, they're even much stronger. Students essentially have full First Amendment rights. But you know, if it's something that's spilling into the school, I think it's maybe going to depend where they put it. It's going to be really fact intensive.
Well, we've avoided talking about the social media, but a lot of the bullying now is happening.
It is.
on
It is.
social media,
Yeah.
and that's a whole new area, and
Absolutely.
some of it's quite brutal because
Mhm.
how it affects a youngster
Mm-hmm.
when it goes viral.
Right.
And then the parents get involved sometimes.
Absolutely. Absolutely. Going back to Stan's first point about in terms of standards and what you can be expelled for, before Senate Bill 100, and this is still the law, but there are caveats to this now, it's gross disobedience or misconduct. Now, how that's defined, I mean, you know, that's going to go to the school code. A board's going to want to be very careful to define what you can get expelled or have a lengthy suspension for. But it's that is the standard in the law: gross disobedience or misconduct. Let's move to the next one. Suspension. So again, it's authorized for acts of, I knew I had that in there somewhere, gross disobedience or misconduct. It's not to exceed 10 days unless on a school bus, and then it's talking about suspension from the school bus. You can kick kids off the bus, which of course, especially before Senate Bill 100, led to a lot of problems in terms of how does the student get to school.
Hard question. It hasn't been signed by the governor yet?
No, it has. This was signed into law last summer. Senate Bill 100 is in effect. It went into effect September 15th, 2016. So this was the first school year. So it's brand new. We don't have any cases on it yet. We'll be talking about the statute and some of the potential impacts, but we're still waiting to see how it unfolds.
We did vote on it as a board, and I assume that all the districts in DuPage,
Mm-hmm.
because we get advice.
Yeah, I'm sure. Yeah, you had to put new policies.
We
Oh,
made it a part of our
absolutely. Yeah.
changes.
So the suspension also has to be reported immediately to parent or guardian. It's supposed to be a written statement. It's a full statement of reasons of suspension or notice and a notice of right to review. So again, that's your due process rights. It's that notice and a right to review. The right to review for your suspension is going to be, well, it doesn't have to be, and it's going to go down to the school boards, but it could be less than for expulsion. It could be a little more informal. You might not have as much right to present certain types of evidence, but it's really going to go down to school board policy on these issues. Again, the review is before a board or hearing officer, and you do have a right to transfer to alternative program suspensions over 20 days. I think to get over 20 days, it's difficult to get to under the law, even under the old one, because, again, it's supposed to not exceed 10 days. I think this maybe has to do with multiple offenses, or it has to do where something happened on the school bus and they can't get to school. All right. Expulsions are limited to 2 years. That's still the case. Did someone say something?
That's a long time.
I'm hearing 2 years is a long time, but it's expulsion. This is kicking them out. I actually think it's interesting that they limit it to 2 years, that someone did something bad enough to get completely booted out of school, and they're going to allow them to come back into that school in 2 years. I didn't know that was the case. So I think that's fair. I think adolescents change quickly enough and have the potential to be a very different person in 2 years. So students shall be expelled for a period of not less than 1 year if they bring firearms or other weapons to school. That's a zero tolerance policy, right? There might be a little bit of discretion, a little bit of wiggle room in cases of a mistake where it wasn't intentional, but we've seen schools enforce this against students where they were out hunting the weekend before and have something in their backpack. I think we've seen some against students with a water gun where they've had very lengthy suspensions. They may also be suspended or expelled. So I said firearms or other weapons. They also may be expelled for internet threats, which we started to talk about. So that has 3 parts, which I think we'll get to in Senate Bill 100 in terms of what that constitutes. But essentially, it has to be on the internet. It has to be directed at a student, an employee, or other personnel, and it has to appear credible. Before Senate Bill 100, searches of school property were also explicitly authorized. That's lockers, common areas, parking lots. Also, student property that's left in those areas could be searched. If it's unattended by a student, then they can search through it under Illinois law. It also included a re-engagement policy, and this is important, and it did get stronger under Senate Bill 100. But when students are gone for a while, whether they're expelled or suspended for a long time, they miss a lot of school. They miss a lot of the curriculum, and it's also difficult for them to reintegrate with their class. So Illinois law had that in there, and that's another thing that we look at in Senate Bill 100. I think we're moving on. So before we actually move on to Senate Bill 100 here, I just want to ask everyone if they have any thoughts on where Illinois law was, what you would do to improve that. Any thoughts? No?
I would eliminate expulsions.
You'd eliminate expulsions.
Really? Even for,
I think that's interesting. I don't think you're wrong.
The problem is exacerbated when you take them out of an environment where they're going to be mentored into citizens. So if you expel them and maybe the parents don't have a plan on what to do with them, or because who knows, it's a broken family and they've got problems, then you lack any sort of mentor figures around this
Right.
student. And so this is exacerbating the school to prison pipeline problem.
Yeah.
And
Well, that's the basis of the whole problem, right? So.
If you've got some sort of program in the school,
Yeah, and that's the alternative schools, and they do for students who I believe I don't know if it's I think it's actually just before high school graduation they have to offer alternative school, and there are situations where they can be kicked out of that as well. But Miriam, were you going to ask about that?
also be expelled from alternative.
Yeah, it's going to be a lot tougher to get them for them to be completely kicked out, especially.
I don't know what alternative schools do, but I think that you should still have something in place for these students who,
Yeah.
some sort of special corrective
Yeah.
program so that they can learn what is behavior that is acceptable and what is not.
Do you think age matters?
Yes.
How so?
Age matters in terms of how the student reacts to the punishment or
Yeah.
to
To intervention?
to intervention. Okay.
Yeah.
If students are not young enough to understand
Yeah.
the offense that they've committed,
Yeah.
then
That's exactly
you need to
right.
take a different approach than
Yeah.
somebody who is able to understand.
Yeah.
So what do you do with someone who threatens someone over the internet? A student who threatens to bring a bomb to school or a weapon to school for a shooting? What do you do with someone like that?
I don't have all the answers.
Yeah, and I mean, maybe this is sort of that, if you get expelled, that doesn't mean you can't go to another school, and they're not supposed to,
That
yeah.
your value as a person is somehow diminished
Right,
from
right,
everyone else's.
right. And, you can go to other schools, so I think this maybe gets into that, I always thought expulsion was forever. Now it can't be more than 2 years. You can be expelled for 1 year, whereas, you can be suspended for 20 days or something and still come back, so.
It has a big
Absolutely.
student.
Yeah.
So I think it makes a big difference
Yeah.
when you tell a student
Yeah.
you're suspended versus you're expelled.
And the other thing that I think Leon started to get to is the different age. It's if you're talking an 18-year-old high school student, I mean that's an adult. Children's person's brain develops through age 25 in a lot of cases. I think is that the average, but so students even through age 18 are still developing. But obviously, there may be more opportunity for intervention if you're talking about a 12 or 13-year-old in middle school and an expulsion versus an 18-year-old who's going to graduate or not in 6 months.
My wife is a registrar at a high school,
Mm-hmm.
and the students that are expelled, to my knowledge, are first given the opportunity to withdraw.
See, and that's a nice option that some of the schools
they go to a
offer, and
private
it's
school.
helpful. Yeah.
But I don't believe, and I can call her and ask her, but that they can necessarily send their transcripts.
That's interesting. Okay.
Something weird.
I know they're able to, like, for curriculum that they've completed. So if they can, I'm not sure with withdrawals, but for expulsions, they're able to transfer the credits they've completed.
Right, if they don't withdraw,
Mm-hmm.
then they are at least in our high school district,
Mm-hmm.
I think in all the ones in DuPage,
Mhm.
do go to an alternative school,
Yeah.
you know.
Yeah.
Did
Stan.
the law before Senate Bill 100 and even after, which I know we'll get to, when you talk about gross misconduct and
Mhm. It's
disobedience.
Disobedience. Yeah.
There's a segment of the population, and those are students in special ed in BD classrooms. That's why they're there.
Uh huh.
Are we treating those students who are being guided the same way as mainstream students? Or that
I especially think before Senate Bill 100 we were. I think there's an attempt to start to get at that in Senate Bill 100, but I don't think you'll see in my opinion we don't go far enough. I think that best practices in terms of teacher training, we're trying to teach not only the differences between each student, but differences between cultures and everything. How if you have students who grew up in two different areas, it can be a very different reaction to discipline and to different types of discipline. That's where I start to get into as well with talking about how inherent bias, we're talking about a cultural shift. It's really in terms of discipline and effective discipline and work in the classroom as well.
I have one question.
Yeah.
Regarding the alternative school, does that, is there more than one district can send, or is it the district itself that sets up of the alternative?
We belong to a cooperative,
Right.
Mm-hmm.
and there's a number of cooperatives.
Now, there were cooperatives and still are for special need kids. Now,
Mhm.
this is a cooperative for discipline.
Right. I believe the alternative school is also under the direction in our area of something called NEDSEC.
Oh, the same? Oh,
And, but there are a number of them. I just
Yeah.
learned that last night as a matter of
Yeah.
fact.
well, I'm surprised now that some of the high schools now are no longer going the route of the special needs, but cooperatively setting up something else.
Oh, the special needs falls under that also.
Yeah.
But
Yeah.
I had one situation where they broke away from special needs.
Hmm.
So I guess,
Yeah, and I imagine a lot of the questions have to do with resources within the school and the district and what they can set up, as well as possibly needs depending on the district.
I know some students have even been sent out of state, because they had such profound
well,
needs.
there's been a lot of
Mhm.
scandals associated with
Right.
students sent out of state.
Yeah, yeah. So Senate Bill 100. It is intended to address the school-to-prison pipeline. That was a major consideration for lawmakers in passing this law and having the governor sign it. It's meant to implement equality and add due process rights for students beyond what they are constitutionally provided. It encourages best practices to begin with. They are supposed to create a memorandum of understanding with local law enforcement. It's a little bit of a stronger requirement. That's actually a recommendation for the memoranda, but that was not previously in the bill. it said that these parent-teacher committees should work with the board to get towards that policy, but it didn't have a recommendation that it was an actual written memorandum. That's important. Yes?
Is there any resource that provides the best practices for the memoranda of understanding?
That's a great question. I bet you the Illinois School Board Association has some guidance on that. I haven't seen, but that almost must be something that they would provide guidance on. I guess maybe if we want to talk about the Naperville issue, this might be a good time as well, in terms of there was a situation that happened at a Naperville high school where a student was accused of passing a video of him engaging in sexual activity with another student. He was 16. I think the other student was supposed to be 16 or in his grade. He was in the middle of lunch period, I believe, and was pulled out, brought to the office. And the administration accused him of having child pornography. They said he was going to have to register as a sex offender. His parents weren't in there. He's in the office. They called his parents, and after they had interviewed him and tried to get him to admit to this and pass his phone, I think they did download his phone, and it turned out there was an audio file on there, but no video or pictures. They put him in a room alone to wait for his parents to get there. When his mother arrived at the school, and had they already brought in the police officer at that point?
Yeah, I think the police officer was there.
Involved in the questioning of him. Wasn't read his rights or anything. Parent wasn't there.
It was like an 8-minute
Yeah.
conversation or something like that.
Yeah. And they said he was going to have to be registered as a sex offender. They called his mom. They told her that he was being investigated for child pornography over the phone. She got to the school and they couldn't find the student. He had left. They found his backpack. His car keys were in it, so they figured out he hadn't driven. A police officer a few blocks away drove by and saw him on the 5th floor of a parking garage. Before the officer could stop and get in position to investigate, he had jumped and he died. That probably highlights why you need a memoranda of understanding with local law enforcement. In my opinion, it's going to be interesting going forward, because this happened recently, correct? Like 2 days ago. I mean, it's going to be interesting because on the one hand, I think if the police officer hadn't been in there, I think it would be extreme for a principal to talk about the criminal side in here. The principal should not be talking about having to register as a sex offender. That's completely out of the power of the school. Obviously, principals are allowed to question students without parents there. With the officer in there, I think there are going to be some serious questions about practices there. That's something that wouldn't have been admissible in court with the officer there in all likelihood. And it pretty directly led to this student jumping off this parking garage.
Almost instantly has to make a decision whether it's a criminal offense has been
Yeah.
committed.
Well, the parents already filed a lawsuit,
Yeah.
according to today's paper, and I think they're arguing that they illegally questioned
Yeah.
the child without having contact with
5th Amendment,
You know,
6th Amendment.
I understand the case, but I'm talking generally.
Yeah.
On school grounds, somebody has to make a decision.
Sure. If there's a criminal offense. Well, but once the police are involved, they should be following police procedure, right? They shouldn't be. It seems they were still following some kind of school procedure and still questioning him, calling his mom into the school. Maybe they should have just said, we're not going to say anything, we're going to take you over to the station. But then there's the question also, I mean, we're getting deeper into school board policy here, but leaving a student who's just been accused of a...
About memorandum of understanding, Argo High School has a memorandum of understanding with the Village of Summit.
Mhm.
I don't quite understand the relationship of the resource officer in school and the village.
Sure. And that actually is a very complicated issue. We've talked about this a lot. We go to Downers Grove South every year on their Constitution Day, and one of the resource officers sits with us on a panel. And it's this very murky situation, honestly, where it's are they a cop or are they a school employee or somewhere in between. I think it comes down to often what is the context of what's going on. Are they being investigated for a crime or are they being investigated for breaking the school rules and what it can lead to? Where you have something that serious and this boy had apparently without his partner's consent, audio recorded the situation. So that's certainly, if he did it, that's going to be some form of crime he's passing along in school. But if they're investigating him for a school violation, it's one thing. But where you got this crime, there probably should be a tendency to worry much more about due process and what his rights are.
I had an opportunity to talk to resource officer just generally about active shooter kind of thing, and that's getting really serious across the nation.
Yeah.
And he says, we have exercises we go through on the school grounds for that situation. It's quite a situation now to be in school and you got to.
Oh, I know. Miriam, did you have something?
I was going to say at Downers Grove South, the way that they've explained it on the panel at the Constitution Day event, all-day event, is they pretty much do delineate it. Like when we start wondering about whether
It's criminal.
offense has been,
Yeah, a switch should flip, really. I mean,
that's kind of where
yeah.
years change.
Yeah.
And wearing a different hat. They're no longer the school liaison officer. Now they're the
Yeah.
police officer.
And I'd say that's where Senate Bill 100 maybe doesn't go far enough, because that sounds like best practices. But it's left to the school boards to implement this. I think it's also, from a school standpoint, whether it's a criminal situation or not, after a student has been accused of something that could lead to serious discipline, it kind of amazes me that their idea would be to leave them in a room alone. It's heartbreaking.
Regarding the presence of a gun in the school.
Sure. And then, those situations are, yeah. Oh, absolutely. With the resource officer, having it, and security in the schools, it is. I was also just going to say that community input is expanded. They do call in Senate Bill 100 for more community input.
Oh, is there anything else that you know about that? Or is that something that the school district set in the policy, how that community input happens?
Let me see, actually. I have the bill with me. The community input, so it's still through the parent-teacher committee, but I talked about how they talk about bullying now rather than just searches and a few of the other policies.
Does the act actually define bullying?
So what it does is they talk about and bullying prevention. So previously the law said to establish and maintain a parent-teacher advisory committee to develop with the school board policy guidelines on pupil discipline, including school searches. Now it says and bullying prevention as set forth, and it's this new section of the school code that went into effect a few years ago. So it's bringing in explicitly, they can talk about other things, but this is explicitly telling them to talk about bullying. And that's going to, I think, be a big topic for parent-teacher advisory committees.
And that's the avenue by which community input can be given.
Not just can be, but it's actually mandated that the school board work with the committee. Now, there are no formal requirements about how they implement those, but they do have to set those up. This is a big one. No zero tolerance policies unless required by law. That's pretty big, right? You can't say, well, students get in 2 fights, they're gone. That's blanket, zero tolerance. Now, they could still be gone after 2 fights, depending on the situation. If they practically beat 2 students to death, I think there's an argument that they could be expelled for that. But they can't have that as the set rule. It retains a requirement that students must be expelled for at least 1 year if they bring weapons. So that's still in there. It also retains the exception for internet threats. There may be other requirements in federal law or state law. I was not able to track any down. I assume if there are, they probably relate to drug offenses as well. Expulsion, suspensions more than 3 days, and removal to alternative programs are now a last resort. This is really important. They may only be used if other appropriate and available behavioral and disciplinary interventions have been exhausted and the student's continuing presence would either pose a threat to safety or substantially disrupt, impede, or interfere with the operation of the school.
Tinker standard.
That is the Tinker standard at the end, correct. Correct. So that's, getting, and it's funny that it is the Tinker standard since we're talking about speech. I can't imagine a student just talking so much that they expel them from school, but it does.
But it would depend what he or she was saying.
That is true if it's a threat. Well, but then it's of course not protected under the law anyway if it's a threat. So, but this is really interesting, and this gets to those standards that we're talking about. So. It doesn't directly give you standards of what is this gross misconduct, but what it does tell you is that for those really serious penalties, it has to be a last resort. They have to have exhausted these other methods. Maybe they've suspended them a couple of times already, and they're still coming back and really interrupting class and causing major controversy, hurting other students, or completely interfering with their ability to participate.
I've been going to school board meetings a long, long time.
Mm-hmm.
At the high school and the grammar school 6 blocks away from me. Invariably now, every school board meeting has an executive session for discipline.
Yeah.
Mm-hmm.
I'm wondering, all these discipline problems, I don't know, I guess it's getting very sensitive, and and even minor discipline problems now go before a school board in
Yeah.
executive session.
And I think that's a little bit of them trying to cover themselves from potential liability, maybe rather than the actual threats to it. But I agree, they do have a lot more review. This is setting up some more due process to make sure that they're giving these students enough due process. Anything else?
We've only had one, and
Yeah,
So-
Miriam.
I'm sorry.
no, I just
No,
was
it's.
saying, I just-
Oh, I have a question. So you mentioned that part of the process is that a written statement for the expulsion is given, and then the
Yes.
parents may opt for having, or is it mandatory after that to have the hearing, or is it that they can opt for it?
Now they have to request that the parents come for a hearing, but I suppose if no one shows up, they might still review. I would say best practices would be that they review it anyway, make sure they didn't make any mistakes.
So that's like a different. So when the child or student is first suspected of some kind of
Sure.
offense that would lead to expulsion, they have that like a preliminary kind of a hearing. But you're saying this is a separate hearing that they can ask for after.
No, the preliminary. I mean, it would just be a principal talking to the student.
That's not considered the hearing. A hearing.
No, but they do need to do that. And what happens is it's the board is always the one authorized to dole out punishment. But for those initial decisions, they are able to delegate that to a principal or another designee. There are new requirements for written expulsion and suspension decisions. And I think these are also very important in terms of normalizing the process and making sure that you're treating people fairly. I think writing down punishments that you're doling out and the standards for giving those, it makes it a lot tougher to kind of delude yourself into thinking that you don't have certain biases if it's coming down that way. And there's then a paper trail for it. So written expulsion decisions must detail the specific reasons why removing the pupil from the learning environment is in the best interest of the school. It has to have the rationale as to the specific duration of the expulsion and previous interventions or determination that there were no other appropriate and available interventions. So they have to tell you why they're expelling you, and they have to say that they've already suspended you 3 times. That they can't just give you this expulsion and not explain why they've reached that level, that exhaustion of the other means.
What's troubling, based on what's on the slide,
Yes.
is what's in the best interest of the school.
Mm-hmm.
We don't see anything, at least.
Yes.
What's in the best
Yes.
interest of the student?
Yes.
I mean, there
Yes.
might be some advantage to take the student out of this environment for his
Yeah.
or her sake.
And they do have some language focusing on students, and we saw on the previous slide about impeding students' abilities to learn, and there is a focus on that, but it doesn't do too much to define that. And I do think there is room for school boards to make a pretty tight standard where they can expel students fairly quickly under this. I think that's one of the potential flaws of Senate Bill 100, and I think we'll have to wait and see how it plays out. I imagine what will happen is that this will start to get the problem in terms of inequalities, but I think we'll have a long way to go afterwards still. Similarly, for suspension decisions, they must detail the specific act of gross disobedience or misconduct and the rationale for the specific duration. If they are longer than 3 days, and only if they are longer than 3 days, then they must show that the previous interventions or the determination that there were no other appropriate and available interventions. So again, that's that if it's longer than 3 days, they have to show that they have exhausted lesser punishments.
Do you think that's going to result in expulsions of fewer than 3 days? In more,
Suspension?
I'm sorry.
I think that, I don't know that you'll see more. I think that you'll see a lot of suspensions that were going to be 5-6 days lessened to 3 days. And, you know, is that a wonderful outcome? Maybe not. Maybe students shouldn't be suspended at all, or maybe it should be 1 day or an in school or something. But it's a lot better than an expulsion or, you know, a 10-day suspension.
Does the bill cite in-school suspension versus out-of-school suspension? Because a lot of folks figure if you did out-of-school suspension, you're almost rewarding.
Yeah, I know.
So he or she can go home.
I know.
Sit down and.
No, it really doesn't. It really doesn't get at that. And you know, I think that it talks a little bit about like alternative programming type things. I almost think that you could have a situation where an in-school suspension might not be considered under this law. I guess it would depend on the specific situation. But no, that is an interesting question, and you know, that's another concern with sending them home, though, right? I mean, the entire point is we don't want students at home, especially if they're not going to have parental supervision at home.
Because you're impeding their cognitive development.
Absolutely.
I don't believe in practice the way that we interpret it as a board is that there would be more in-school suspensions and that you would,
Yeah.
you know, it
Yeah.
just really made it much more
But
difficult.
yeah, and in-school suspensions, that's much more resource intensive on the school.
Yes,
So.
that was a consideration, you know, that even you'd have to have somebody go with a student if the student is disrupting or makes other children afraid, you know.
One should be.
Yeah.
The thing that, you know, this is all after the fact, the kid has done something wrong, he's suspended or expelled. Are there any preventive measures or the kids taught so that they don't indulge in these behaviors? What does the bill say about the school's responsibility
You know, yeah,
for prevention?
the bill doesn't talk too much about that. At least I'm trying to think. I didn't cover anything with that, and I don't think it talks about it too much. You know, one thing that I actually missed earlier, I wanted to ask when we were talking about due process. Are there situations where you don't need a hearing and you suspend a student for a long time?
You know, even though I voted on the SB 100 and read it, but we don't have
Yeah.
big problems, fortunately, in our district.
Yeah.
But
And
I think you'd always have to have an hearing.
I'd say best practice, you, Leon.
That's kind of what due process is. It's process that is due.
So,
If you're risking some restriction of liberty or property,
yeah.
then
Well, so what some of the district courts have said is that if a student has noticed that this particular behavior, and this is getting to zero tolerance policies, if they have particular actual notice that this particular behavior is going to get them suspended, and they either admit to it or it's just, you know, completely obvious, that they can be suspended without a hearing. And I think that's really interesting. I think it's troubling. It's at the district court level, so you know, if that got kicked up the line to the appellate courts or Supreme Court, I don't know what would happen. But yeah, they said clear violations of a written rule or if the student just admits to it.
Let's attempt, certainly after many years, to get some structure to this process. I think the saddest thing is the student shows up and the parents don't.
Yeah, I know.
That
I know.
happens a lot.
Yeah. And that's another major problem I think is still here completely with Senate Bill 100. We get to that same situation where you have students whose parents aren't involved in it or can't be, right? I mean, there are plenty of parents that
Or
work
they don't have
nights and,
anything to do with their
yeah,
kids.
so it's, you know, it's really tough. All right. So, we sort of got at this from the actual policy, but it says specifically in there, schools are to limit expulsions and suspensions to the greatest extent possible. Suspension of 3 days or less only if students present would pose a threat to school safety or a disruption to other students' learning opportunities. So again, they're trying to suspend you less as a punishment and more as a preventative measure in terms of other situations. They have support services are demanded of the school districts during suspensions exceeding 4 days. So getting them assignments that they're missing, things along those lines, making sure that they have some form of supervision over those 4 days or more. Again, the re-engagement policy is expanded. It's expanded to include school bus issues. So they talk specifically about if students are suspended from the school bus and can't get to school, they have to figure out an alternative to either get them there or get them to another program. And it also says that school officials shall not advise or encourage students to drop out voluntarily due to behavior or academic difficulties. I've heard sort of rumors of these situations. I don't know them specifically, but in a way, it's almost what Mike was talking about with students choosing to withdraw. But under Senate Bill 100, they can choose to withdraw, and I think school officials can certainly still allow them that opportunity, but they can't actively encourage it, and that's important. This is one that easily could be abused. You can think about it. Issues with academic standards. Some of the federal law still requires you, still hurts you in terms of funding if you don't do well on tests. Well, you got a student who's underperforming, school can try to get them out of there, right? Well, now they can't push for that under Senate Bill 100.
These are bills that are not written.
No, this is the law. I know, it's confusing. It is confusing because it did not have a good name and they just called it Senate Bill 100. Everything you see online about it, it is under Senate Bill 100. It's a really stupid name.
Now it's actually a public act.
It is public act. It is a public act. It is public act. Let's see here. I believe it is.
Give it a name eventually.
No, because it's just amending the school code and it amends a few different provisions.
Okay.
So it's yeah, there are a few different that it refers to here.
That first bullet point there doesn't look like it's really a provision. That looks like maybe it's from the preamble, more like a policy statement about the law, because it doesn't sound like it's something that's actionable under. I mean, like, how are they?
Yeah,
what's
and
the
that's
date
another
for
issue.
schools
Yeah,
literally?
I would say that's another issue with this. A lot of this relies on school policy to implement, and it would be pretty difficult to prosecute that. So I would agree.
I mean, what claims? Who has a claim under these laws to find a school to be in violation of these rules?
I think the State Board of Education would, and beyond that, I think if a student were in a situation where they were expelled and shouldn't have been, and then they're trying to get it back in, not only would they have their constitutional due process claim, but I think they could claim under this act that there's a cause. It does not explicitly give another cause of action. I think they would have to probably say that the state is granting them those rights under this and couple it with any due process concerns. But again, it's the first year, so I'm sure we will see some wonderful litigation over the next several years.
I think the last bullet point, school officials not advised and encourage students.
Yeah.
There's a two-word description for that. That's racial profiling.
Yeah. I mean, as I said, and as I said, this thing is directly aimed at the school-to-prison pipeline. So they very, and it was nice. It had bipartisan support, and Governor Rauner signed it. So.
And those statistics you gave earlier about the number of black students expelled for first-time offenses, I was curious, what's the percentage for white students?
No, so it's twice as many. The rate is there are twice as many black students as white students as a percentage of their population for those first suspended.
Of the overall population, or
Yeah.
the population of the school?
Hold on, let me see here.
Like how race is presented, with the proportion of that race in the overall population, or the proportion of the racial breakdown of the school? I guess it would be
Not the racial
of the
breakdown of the school, they're saying the population.
Black
Yeah.
students are.
Yeah, here you can look at this, and I can give you the full document. It's from
And
the
then, you know,
ACLU, I think.
I mean, how, like?
Or no, it's from the
how
American
did
Bar
they-
Association.
Was it just black and white, or was it also Latino?
The full ABA study, yeah, the ABA has a really great long document. It's like 90 pages on this. They talk about all races.
The ABA?
Yep, they have a good overview of it. I think that's what I think it's the ABA that's from. I can give you the whole thing. It's a good document that covers a whole lot of these issues. I mean, the whole thing is the statistics have been covered, inside and out by a lot of different groups. ACLU, the ABA has all these different education groups. I saw some Congressional Research Service reports on it. The question is policy and implementing policies to combat it. So I think Senate Bill 100 starts to get there. I think we're going to see some areas where we still need to improve on it.
Seems to me there's a lot to swallow if you're on the school board.
Yes, and
Detail here. Some needs to be interpreted.
yeah, absolutely. And I think that they'll be looking to guidance from some of the bigger school districts and from the state, the school board association and all these other groups. That they'll be trying to get the professional development courses on it. It's gonna be interesting to see as they continue to develop it.
Applies to City of Chicago public schools.
Yes. Yeah, it's aimed directly at that. And then there's other legislation aimed at those right now in terms of more outside the school, but they think is going to affect students as well. So briefly, because I think we're almost out of time, I just wanted to bring up college campuses. I know Leon has some experience with the discipline on college campuses. What additional considerations must we make for discipline on college campuses?
Does that law not apply to college campuses?
No.
Only schools?
Yep, primary and secondary schools.
Why?
Yeah, age is the big one. You're dealing with residential situations here. It's tough because certain things, your constitutional rights, that they probably should, and the Supreme Court would try to tell you that they apply equally to a high school and a college. But then in reality, when you see a lot of the factual situations, it's just too dissimilar to.
We're talking public or private colleges?
Well, both. I mean, I think that private colleges often are brought in because they receive a lot of federal funding as well. So what considerations do you think you need to make about discipline on college campuses that might be different from high schools?
More instances of
Sexual assault. I mean, I mentioned it's a residential situation, right? You have people living there.
Well, not all.
Not all,
Fewer
but
schools.
a lot of them. But maybe at a public university, you could have, let's bring these two things together. You have more instances of sexual assault, and you can have the victim and the perpetrator in the same dorm.
What
At
if
U
you
of
live off
I, it
campus?
could be football players burglarizing their dorm. They got
Is that a
kicked off
reason?
the football-
Oh,
yeah,
God.
Kicked off the football team.
Yeah.
Lovie Smith kicked them out.
These-
The other question is, we were talking about the schools, but then, and the problems in the schools and discipline and suspension. But when you look at the CDC report, the CDC wrote a report. Every year they write one on public health.
Mm-hmm.
And the CDC report is on 6 points of public health for kids or whatever, younger adults. And those 6 points should be covered in the procedures and applications on best practices, and they're not. Because the CDC report says
Yeah, I'm not familiar with the report, but it's
there are 6 areas like
Yeah.
drugs, sex,
yeah.
public exercise and diet.
Fatigue.
So the CDC report says there are 6 factors
Yeah.
that are affecting the young people.
Yeah.
Mental health
Huh.
could be one.
Yeah, I'm not familiar with it,
None of this ties into the CDC health report, which is revised every year, and they put out big statistics and everything, and they do like
Yeah.
14,000.
Yeah, and I think that there are probably other areas of the school code that try to account for some of that, as well as individual district policies. This in particular, the Senate Bill 100 was aimed at this particular situation with the school-to-prison pipeline. But I also think that those are maybe a consideration as we talk about colleges as well, since this is outside that Senate Bill 100 context. As I started to get at, these are residential situations. So you have this interesting construct. They're also adults. So you have this interesting construct where the school might need some power to intervene because you have a potential victim and a potential perpetrator located next door to each other in a dorm. But you're talking criminal offenses, and we're talking due process. It's a really difficult situation. So we've seen schools struggle with this. We've seen the press struggle with this. The infamous Rolling Stone article about University of Virginia.
Well, we've got 50 states.
Mm-hmm.
They're all different. In Texas, if I'm not mistaken, allows open carry and
It does, yeah.
now that's got to be very frightening.
That's
Yeah.
guns or alcohol.
Guns, yeah. Yeah, you can carry guns on campus in Texas. It was a big deal. I have yeah.
With people carrying guns.
I think what's important is a realistic leadership on the part of the college administration.
I agree with that. I think a big part is implementing policies that actually work, having set policies of how you're going to investigate something. And we've seen, my alma mater, Tufts, got on the Department of Education put out a list of schools that were not properly complying with Title IX in terms of sexual harassment on campus, and my alma mater was on there. And it's a lot of them. They don't know how to handle these situations, and I can tell you from talking to friends, you get the same facts twice, and the school's handling it two different ways. So you're exactly right in terms of.
I think they have to be realistic up front.
Yeah.
Not just issue a list and let it go at that, I think.
Yeah, I agree. Well, I think we're running out of time. I'm happy to talk a little bit more about college campuses, but I think it seems like everyone. Great. Well, thank you all for coming. We do not have any more of these in our series, but stay tuned. We will have more discussions here, and we hope you can join us at our next events. Thank you.